Hello everyone, welcome to Learn Law with AKP. In today's class, we are going to discuss an important topic under contract of bailment, termination of bailment. We already understood definition of bailment, essentials of bailment, kinds of bailment, rights and duties of bailer and bailee. Now, the important question is, how does a contract of bailment come to an end? This ending of bailment relationship is called termination of bailment. This topic is important for exams as well as practical understanding. So, let us begin. Termination of bailment means the ending of the bailment relationship between bailer and bailee. Once bailment terminates, bailee must return goods. Rights and obligations come to an end. Termination may happen in different ways depending on circumstances. Now, the first and most common mode is termination by completion of purpose. When the purpose for which goods were delivered is completed, bailment automatically ends. When the purpose for which goods were delivered is completed, bailment automatically ends. For example, you give your bike to a mechanic for repair. After repair and return of bike, bailment ends. This is the normal way bailment terminates. Second one, it is termination by expiry of time. Sometimes goods are bailed for a specific period. Once the time ends, bailment also ends. For example, a person rents a laptop for 1 week. After 1 week, the bailment terminates. The bailee must return the goods immediately. Now, third one is termination due to unauthorized use. If bailee uses goods in a manner inconsistent with the agreement, bailer may terminate the bailment. For example, a person borrows a car for local travel but uses it for illegal racing. This misuse allows the bailer to terminate bailment immediately. Unauthorized use creates liability for damages also. Now, the fourth is termination due to destruction of goods. If goods are destroyed or become unusable without fault of parties, bailment ends. For example, a warehouse storing goods gets destroyed by natural disaster. Since goods no longer exist, bailment automatically terminates. Now, let us understand termination of gratuitous bailment. In gratuitous bailment, the bailer may terminate the bailment at any time before purpose completion. However, if early termination causes loss to bailee beyond benefit received, bailer must compensate. If early termination causes loss to bailee beyond benefit received, bailer must compensate. For example, a person lends a machine free of cost for 1 month but demands return after 1 day, causing loss to bailee. Compensation may become necessary. Now let us understand an important case law related to bailment responsibilities in Coggs versus Bernard. A person agreed to transport barrels without payment. Due to negligence, goods were damaged. The court held that even gratuitous bailees must exercise reasonable care. This case indirectly explains that misuse or negligence may end bailment and create liability. Here, the principle established is Failure to perform duties properly can create legal consequences in bailment. Now, let us quickly revise the modes of termination of bailment. Bailment may terminate by completion of purpose, expiry of agreed time, unauthorized use by Bailee, destruction of goods, termination of gratuitous bailment. These are very important exam points. Let's conclude this topic. Termination of bailment means the ending of the relationship between bailer and bailee. It may happen due to completion of purpose, expiry of time, unauthorized use, destruction of goods, or termination of gratuitous bailment. We also understood through the important case of Coggs versus Bernard that negligence in bailment creates legal liability. So remember, when the purpose or agreement ends, bailment also ends. For exams, always remember modes of termination, examples, and legal principles. Thank you. If you found this video helpful, please like, share, and subscribe to Learn Law with AKP. Stay tuned for the next topic.